So yes, it is very early. It's 7 a.m. Monday morning, and today is the day that Djokovic finds out his fate with the court. So overnight or late last night, the Department of Home Affairs filed their submissions to the matter, and we're going to go through those before the hearing. I'm hoping that afterwards, Poppy Seeds, if she's available, because she isn't just at my beck and call, but I'm hoping that Poppy Seeds will be able to come and do will be able to come on my stream, can join me and can explain what's going on, because as I said, this is what she does, migrations. So it's really good. Look, there was an order that came about, which was really interesting, and it was made on Saturday. So we'll have a quick look at that, and then we'll have a look at what the feds responded with. Now, rather than being 38 pages, it's only half of that. I have been told that while Djokovic has four barristers and two top QCs, the Department of Home Affairs have two junior barristers. One been a barrister for around 5 years. The other one, it has only been a lawyer for around 2 years, so brand newbies. However, I have been told that they are both guns, which is really, really amazing. Hello, Totally Clueless. How are we? So let's have a look at the order that Judge Kelly made on Saturday regarding this, and it also will explain why we can't see the affidavits. Then let's have a look at what the government argument is, and then try and piece together what exactly is where we are. And I will be attending today. So I'm really quite excited to be able to sit in and watch this proceeding. I also believe that Djokovic will be giving evidence via video. Well, it is a virtual hearing because the courts are not opening because of the high COVID cases. So let's have a look. So this was an order made on the 8th. When was this one made? Sorry. Yeah, this was made on the 8th. This order was made on the 8th. So we're at the 10th now. This is popcorn. This is like popcorn stuff. This is, who needs TV when you got this playing out? So you got QC, two lawyers for the applicant, and you've got, as I said, they're junior barristers. I've had a quick look. This is again a very well written document. I heard that he said he was exempt because he previously had COVID. Is that a general rule in Australia? No, Totally Clueless, it's not. Previously having COVID will give you an exemption from the vaccine for 6 months, and that's what he's going to be explained in this document, actually. But that's what he used. So the court orders that the parties be allowed to appear and make submissions before the court by video and audio link. So it is going to be video because it needs to be a video link. The application in a proceeding filed the 8th of January that the final hearing be adjourned to Wednesday, the 12th of January, be refused without prejudice to any application that the respondent may seek to advance after the conclusion of the applicant's oral submissions for an adjournment before the respondent's oral submissions be made. Now, this is all going to be sorted out today, I believe. That's my understanding. The government had asked for for it to be done till Wednesday because, I mean, this is rushed. This was rushed. This was put into court. This was put in the court on Friday, being heard on Monday. Until further notice, no affidavit be admitted to the public compartment of the court file. So this is why we've not seen the affidavits. The affidavits are not being made public. So the parties agree that oral submissions at the final hearing should be no more than 90 to 120 minutes in duration. So each side is 90 to 120 meters. Yes, that's a good point. I mean, I do think that too, Sonia. Subject to any further application for an adjournment, the respondent is to present their submissions at 3 p.m. on Monday, the 10th of January 2022. All right. So by 3 p.m. So it's 3 p.m. on Monday, the respondent is going to be responding. Funny that. Okay. As I said, I'm going to see, hopefully Poppy Seeds is available once this is all done to take us through and explain in terms that I can understand what's happened, how we got to here, and the outcome. Now, she did say to me that even if Djokovic wins, the government can still cancel his visa. They can just refile paperwork and make sure all their I's are dotted and their T's are crossed. So it essentially really could be a lose-lose for Djokovic. And if he's deported, he won't be allowed back for 3 years. All right. So this is the Department of Home Affairs, the written submissions. So the applicant seeks judicial review of a decision of a delegate of the respondent to cancel the applicant's visa under Section 116 of the Migration Act 1958. I might also say, before we get to point 2, is that there's so much community anger that even if Djokovic is allowed to play, he might find the community response will be not very nice, and he may have wished he went home. But that's another. I mean, there's so much anger at the moment about him even being allowed in the country. Point 2. The court has jurisdiction to determine this matter under Section 4761 of the Act, even though this decision was made by a delegate. While delegates' decisions are usually excluded from this court's jurisdiction by Section 476 as a primary decision, it appears to be common ground that the delegate's decision in this case is not such a primary decision. That is because it was made while the applicant was in immigration clearance at the airport. Such a decision is outside the scope of review by the Administrative Appeals Tribunal under Part 5C, Section 3383B and Part 7. This proceeding has been brought on for hearing very expeditiously. Interactions with the court during mentions have usefully identified that a matter of primary interest to the court is the procedure that was followed in this case. By determination is required expeditiously, and in light of those interactions, we think it convenient to go straight to these procedural grounds, being grounds 3A and B of the applicant's proposed originating application. So they're going to outline what they've said, and then they're going to counteract it. So ground 3 is put in 2 ways. The applicant contends that none of the events in Section 1241 of the Act had occurred by 7:42 a.m. when the delegate made his decision, so that there was no power to make that decision at the time. There is no dispute about Section 1241A, B, 1B, and C, and the court's focus should only be on Section 1241A only. The respondent's position is that Section 1241A means only that a person has given a response, not a completed response, as the applicant contends. The applicant's position reads words into the statute that are not there, and it may well arm a visa holder with a procedural filibuster, stymieing the operation of what a statutory power, Section 116, integral to the Commonwealth's sovereign rights to determine who can stay and remain in Australia. That is not a sensible construction. The perverse outcome referred to at AS 121, a non-citizen had said something, but not everything they wanted to, is avoided entirely by recognising, as we do recognise, that a cancellation decision can be judicially reviewed for its alleged unreasonableness, potentially, as here, as to its timing. The presumption of reasonableness, which attends the discretion to cancel the statutory check and balance. By contrast, there is no such check and balance on a person who repeatedly seeks further time to respond to an invitation to interview, whatever the reason for that may be. The interpretation would instead permit the ongoing presence in Australia of a person where the delegate considers there to be appears to be a ground for cancelling their visa. That interpretation cannot be correct. Here, there is no doubt the applicant gave his response at interview. He had nothing more to say at 6:14 a.m. and they've footnoted the interview. Again, we don't have access to that. Section 1241A had occurred and there was, therefore, power to cancel. That this ground should be rejected. The applicant alleges that not giving the applicant until 8:30 a.m. to speak to his advisors, again, denied him procedural fairness. AS 128 concedes correctly that the High Court's decision in the Minister for Immigration and Border Protection is distinguishable in that there, the person was given no notice of the change in procedure at all. That is not this case, and WZARH does not control the outcome here. What control outcome here is basic principle. Has the applicant demonstrated practical injustice in the delegate giving him less time than previously stated? He has not for these reasons. So now they're going to outline their arguments. Now, procedural fairness, I think, is probably Djokovic's strongest ground. But again, even if he wins, Home Affairs could still can just re-cancel the visa. So what must be shown to demonstrate practical injustice will vary with the nature of the alleged denial of procedural fairness. Here the allegation is that the delegate relies from a representation. In such a case, what Gagler and Gordon JJ described in WZARH applies. So again, they've got that down there. So there are cases in which conduct on part of the administrator in the course of a hearing can be demonstrated to have misled a person into refraining from taking up an opportunity to be heard that was available to that person in accordance with an applicable procedure which was otherwise fair. To demonstrate that that person would have taken some step if that conduct had not occurred is, in such a case, part of establishing that the person has in fact been denied a reasonable opportunity to be heard. In Waco versus Minister for Immigration and Multicultural and Indigenous Affairs, which was cited by Gagler and Gordon JJ, the full court explained the critical feature in the High Court's decision in Lamb has been that the appellant never said he relied upon representation by the decision maker. Footnote. The leading treatise in this field, likewise, says that evidence would usually be called for to support a finding of reliance in cases where unfairness is said to have resulted from conduct or representations or breach of those representations. Again, I've got footnotes. Here, there is no evidence from the applicant's lawyers about what would or could have been done between 7:42 a.m. and 8:30 a.m., whom he had contacted previously. Further, the applicant had a long opportunity to provide information to the respondent over the course of the evening. He had just gotten off a plane, that is true, but he was flying from Spain, a time zone where it was afternoon to evening. There is no denial of procedural fairness in the decision-making. That is not the case here. Here, the applicant had already had a long opportunity to put representations to the delegate. A decision was made over an hour after the conclusion of the brought forward interview, but no additional information was forthcoming in that period either. The applicant had previously contacted his lawyers, and there is no evidence that his lawyers would or could have done anything in that intervening period, and no evidence that anything would or could have been said in that intervening period that could not have been given to the delegate already. Many decisions under the Act have heavy consequences for a person. This court is entirely familiar with decisions that impact upon persons who claim that their own and family lives are at stake. Nonetheless, the test for unreasonableness is necessarily stringent, and the courts will not lightly interfere with the exercise of statutory power involving an area of discretion. Footnote. There is an area within the decision maker has genuinely free discretion, which resides within the bounds of legal reasonableness. And the court does not determine for itself how the power should have been exercised or interfere just because the court would have exercised the discretion in a different way. The court could well think that it would not have made the decision at that time the delegate did, but that is not the point. This ground, too, should be rejected. So one of the arguments that Djokovic made, if you remember, was that he wasn't given a chance to speak to the lawyer and that things may have been different. So their argument is that at that stage, nobody could have done anything and there was ample opportunity to give the documentations to the lawyers. Hello, Bo. We're just going through the government's response to Djokovic's claim. We're looking at it just because court's at 10 a.m. It's currently 7:16 a.m. and court's at 10 a.m. So I wanted to get this video out there so you can actually watch Djokovic's side and then see the government side, what the government's arguing. Both sides have put through really well-written arguments, I have to say. There is no dispute that valid NOICC under Section 119 of the Act is a jurisdictional precondition to the exercise of power under S116. But this NOICC was valid, not invalid. It seizes upon the undoubted typo in the last sentence of Attachment A of the NOICC. That unfortunate typo is misquoting the provision in one spot is unfortunate but immaterial. Item 8 of the NOICC accurately identified Section 1161EI. The language of S1161EI was on the next page. Attachment A accurately quoted, albeit without quotation marks, in the second last paragraph, and the first sentence of the last paragraph in Attachment A accurately expressed the delegate's state of satisfaction by reference to the language of S116. This submission that the typo in a statement of the ground meant that particulars of why the ground existed had not been supplied consistently with S119 should be rejected. This ground plainly fails. So remember that the job of these barristers or these lawyers are to show the government in good light and paint Djokovic in bad light, okay? As I said, both documents are really written and they both argue their case. All I will say is I'm glad I'm not the judge. Ground 1B is similar but different to and weaker than Ground 1A. The delegate made the same typo in Annexure B, being record of decision as opposed to the NOICC. But the court knows that the reasons for the decision under review are not to be construed minutely and finally, with an eye keenly attuned to the perception of the error. That is what the applicant is doing here. It is plain that the delegate formed the state of mind required by S1161E under item 6 in part B. The delegate ticked S1161E. In the second paragraph of Annexure B, the delegate quoted S1161EI without quotation marks. And the whole gist of Annexure B is about 1161EI. The ground is comfortably disposed of by not departing from High Court's instructions as to proper approach to reading reasons for decision. This ground plainly fails. As I said, when Poppy Seeds comes on, she can explain a lot of this legalese for us. So, ground 1C contains 3 separate subgrounds, and therefore we address them separately. So the first one was the applicant challenges the statement in the delegate's records of decision that previous infection with COVID-19 is not considered a medical contraindication. Hey, for COVID-19 vaccination in Australia. No factual error. There is no factual error here, let alone jurisdictional error. So they're talking about the forms. But page 3 of that form says at the top of the right-hand column, a previous infection is not a contraindication to immunisation against that same disease and aligns with the delegate's records of decision. So AS 44 to 45 then pivots to what the appellant says, calls the ATAGI exemption guidance, but then says people with laboratory confirmation of past infection can start their vaccination course or complete the second dose if they've already had a first dose prior to being infected by SARS-CoV as soon as they've recovered from the symptomatic infection. The evidence that is that the applicant has recovered. Further, the ATAGI exemption guidance has to be read with the AIR form, so that's the Australian Immunisation Registry form, because it says that it was prepared to support completion of that form. That form, as we said above, is clear. Second, the ATAGI exemption guide has to be read with the later December document, which the applicant refers to as the ATAGI vaccination advice. It says on internal page 3, in terms, past infection with SARS-CoV-2 is not a contraindication to vaccination. That is consistently with the impugned sentence in the delegate's record of decision. The applicant relies on internal page 4, which says COVID-19 vaccination in people who have had PCR confirmed SARS-CoV-2 infection can be deferred for a maximum of 6 months after the acute illness as a temporary exemption due to acute major medical illness, emphasis added. But any such exemption has ceased. See above at paragraph 34. Further, the statement about deferral does not say that the person has, contrary to the delegate's statement, a contraindication to vaccination. It says the person can defer the vaccination. That is different, which is no doubt why the document uses different languages for different concepts. Further still, there is no suggestion that the applicant had an acute major medical illness in December 2021. All he has said is that he tested positive for COVID-19. That is not the same. Thus, the ATAGI vaccination advice uses different terms such as mere past infection and also symptomatic infection. The radical and fundamental error for which the applicant contends is thus not made out. In any event, the impunged statement in the record of decision concerns the existence or not of a ground of cancellation. Whether or not such a ground exists is a matter of the delegate's state of satisfaction, a subjective jurisdictional fact, not an objective jurisdictional fact. This does not mean that the delegate's state of satisfaction is unreviewable, but what it does mean is that the scope for review, where the condition on which a power is exercised is the state of mind of the repository of power, such a satisfaction is more limited than where the condition is an objective fact. So we've got another footnote. Again. Now, don't forget that there are also images of him when he states that he had COVID out and about. It was all over Instagram in Serbia. I mean, you could say that there is a risk there of the biosecurity of Australia because anyway, there's lots of arguments, but they haven't put that argument forward. So they've just gone straight to all the procedural and all of that stuff. The applicant seeks to show illogicality and unreasonableness. Those are matters that can violate the state of satisfaction. But the court will well appreciate how difficult it is to demonstrate illogicality and unreasonableness. As to illogicality, it is a high bar. As Robertson J. explained in Minister of Immigration and Citizenship versus SZRKT, just thought I'd also let you know that whenever there is, usually when they're immigration stuff, they're given code names or pseudonyms, and they're usually letters like that. So that is, sometimes it's a refugee, sometimes it's, they're not ever use their full name. So they're given these letter codes. It is not enough for the question of fact to be one on which reasonable minds may come to different conclusions. As to reasonableness, the test for unreasonableness is necessarily stringent, and the courts will not lightly interfere with the exercise of statutory power involving an area of discretion. There is an area within which the decision maker has a genuine free discretion which resides within the bounds of legal reasonableness, and the court does not determine for itself how the power should have been exercised, or interfere just because the court would have exercised the discretion in a different way. For the reasons above, there is not a mere factual error in the delegate's record of decision, but if there were any imperfection in it here, which is denied, any such imperfection falls well short of what must be shown to demonstrate illegality or unreasonableness. That is especially so in the specific context of this case. It is common ground that the applicant is unvaccinated, and there is no challenge to what the delegate said about unvaccinated persons creating a greater health risk of contracting COVID-19 and spreading COVID-19 to others, thus further burdening the Australian health system. Given that common ground and finding illogicality and unreasonableness in the delegate's formation of their state of satisfaction cannot be demonstrated, as Banks, Smith J and Wellahan J have both stated about S116. The words may be or might be lowered the threshold of satisfaction to risk. The delegate's conclusion that this was satisfied was plainly open to them. This subground fails. The second aspect of ground 1C is the allegation that the delegate failed to consider a representation made by the applicant as to why the delegate should not be satisfied of section 1161EI. Paragraphs 31 to 33 of the amended originating application. So AOA is his. So this is what Djokovic said, and now they're going to respond to it. Among the reasons given why the applicant as to why the grounds for cancellation do not exist or why the visa should not be cancelled was that he had been granted a medical exemption by a process involving two independent medical panels, being one, a first independent expert medical review panel, and two, a further independent medical exemptions review panel of the Victorian State Government, in which the process the applicant's identity was anonymised. The exemption document resulting from the medical exemption process recorded that the conditions of exemption were consistent with recommendations from ATAGI. In that the premises, the applicant represented that his compliance with ATAGI principles was a reason why grounds for cancellation did not exist or why his visa should not be cancelled. This second subground should be rejected. The delegate in turn considered the representation made by the applicant that he had a medical exemption issued by Tennis Australia. That exemption was before the delegate, and the delegate referred to it in his reasons, stating the applicant also provided a copy of medical exemption issued by Tennis Australia. That so-called exemption stated that the conditions of the exemption were consistent and with the recommendations of the Australian Technical Advisory Group on Immunisation, ATAGI. The delegate stated that previous infection with COVID-19 is not considered a medical contraindication for COVID-19 vaccination in Australia, and explained in relation to the first subground that that is entirely consistent with both ATAGI documents upon which the applicant seeks to rely. Alternatively, any failure to consider such representations is material because the mere previous infection with COVID-19 is not a contraindication according to ATAGI guidance, and that is the only basis upon the applicant claims to be exempt. Now, I think it's all going to come down to this medical exemption provided by Tennis Australia. My understanding was for the tennis only. It wasn't for entry into the country. We'll have a look later because, Tennis Australia are doubling down and now blaming the governments. And another tennis player, the tennis player that was, there's been another tennis player have her visa revoked, cancelled, and she actually got deported. She decided not to fight it. She's gone home. So, and an official's gone home voluntarily. So, Djokovic isn't the only one that has had his visa cancelled. But it's interesting, Tennis Australia has been very quiet about the other tennis player, but I don't think that person was a high-ranking tennis player, which, in my opinion, shows that this was all about Djokovic. Whatever the cost, we want Djokovic. It might bite Tennis Australia in the backside. Anyway, the third subground proceeds on the alternate assumption that the delegate did not consider a Taigi guidance. Ground 1C does not arise because the respondent does not contend that the delegate did not consider Taigi's position. Rather, the clear inference arising from the delegate's reasons is that he did, because he stated that vaccination is not a contraindication to vaccination in Australia, and that is precisely what Taigi says. Hello, the false. In any event, applicant did not present highly probable evidence of contraindication. The applicant presented a letter from Tennis Australia purporting to provide him with a medical exemption. It does not refer anywhere to contraindication, nor does it give any medical reason why the applicant could not be vaccinated. It follows that any error, as alleged, is immaterial. Even if the delegate did not consider a Taigi, it would not have mattered because the applicant did not provide evidence consistently with the Taigi recommendations that he had a contraindication to vaccination. Ground 1D complains that the record of decision states the traveller must provide evidence of a medical contraindication provided by their medical practitioner, whereas Section 5.3b of the Biosecurity Entry Requirements, human coronavirus with pandemic potential, determined 2021, and he says the person must declare that they can do so. There is no error in the record of decision, because the reference to a person having to provide that evidence should be understood, as AS 70 prophylactically and accurately recognises in the context of Section 5.7, which requires a person to produce the medical evidence upon request. AS 70 says the applicant could not have breached this because he wasn't asked for medical evidence. He gave it all before he was asked. That would defeat the determination if a person could sneak around the provision by providing something first before being asked. The point is that a person must be able to provide something that meets the substantive requirement. So that takes us to AS 71 to 74, which the applicant again prophylactically and accurately recognises must be the true killing ground here. Was he open to the delegate to find that the evidence did not show a medical contraindication? That takes us back to ground 1C. That ground fails, so the answer to the question is yes. This ground must fail. Gee, they like the big words. Oh. Okay. Ground 2A alleges that the delegate failed to consider representations made by the applicant and recorded on Part B, Point 8 of the decision record, internal page 5. Whether the delegate considered them is a question of fact. It is implausible that the delegate recorded it there without considering them all, and it is a significant thing to find. Okay. Indeed, the delegate can be seen to have considered these matters under client circumstances in which grounds for cancellation arose, whether there were any extenuating circumstances beyond the visa holder's control that led to the grounds existing. The applicant describes this as a grossly inadequate summary of the representations made, but that is not to the point. The question is, were they considered? In Home Affairs versus Omar, the full court approved at 36C the following passage from the judgment of Keith Full J in Tickner versus Chapman, addressing what is meant by the obligation to consider. To consider is a word having a definite meaning in judicial context. It requires that the minister have regard to what was said in the representations to bring his or her mind to bear upon the facts stated in them and the arguments or opinions put forward, and to appreciate who is making them. From that point, the minister may sift them, attributing whatever weight or persuasive quality is thought appropriate. However, the minister is required to know what they say. The answer must therefore be yes, they were. They are expressively recorded in Part B, Point 8 of the decision record. They are repeated in Part B.9 in a way that demonstrates the delegate must have considered them and then attribute them to the weight or persuasive quality he thought appropriate. That was the role of the delegate. It is not for this court to second guess the weight the delegate assigned to them. When the applicant in truth asks the court to do so, is to slide into impermissible merits review and make a finding that the applicant had in fact done everything he'd been asked to do in order to ensure his entry into Australia, and that material given to him by the department informed him he'd done everything, even if the representations in fact made can be understood in this way. It does not mean that the delegate was required to accept those representations. This is because there is no such thing of an assurance of entry by a non-citizen into Australia. Rather, there are criteria and conditions for entry and reasons for refusal or cancellation of a visa. Section 1161EI is one of those reasons for cancellation and reflects the power and the responsibility of the Commonwealth to determine who is entitled to be in Australia. That power and responsibility are fundamental attributes of Australia's sovereignty, and for material given to the applicant by the department, it had not been represented to the applicant that his so-called medical exemption would be accepted. The email from the department stated that the applicant's responses to his Australia's travel declaration indicated he had met the requirements for quarantine-free travel into Australia. But that says nothing about the power of the minister or her delegate to interrogate those responses, the evidence upon which they were based, and conclude that a cancellation power was enlivened under the Act upon his arrival into Australia. We reiterate that all this simply invites impermissible merits review. The arguments are addressed only for the purpose of showing that even if this court were to infer the delegate did not consider something they expressly recorded they had considered, it would not be material, because the content of those representations only needed to be stated to be rejected. Ground 2B challenges the part of the delegate's record of decision under the heading Client Circumstances in which the ground of cancellation arose, whether there were any extenuating circumstances beyond the visa holder's control that led to the grounds existing. The delegate found that the circumstances were not beyond the applicant's control and therefore considered that this weighed significantly in favour of cancellation. The applicant's grounds of review is that this is illogically or irrational because the absence of extenuating circumstances could only be neutral or irrelevant, not adverse. This ground should be rejected. First, the applicant's arguments amounts to contention that no reasonable person could regard the fact that the ground for cancellation arose due to matters within the visa holder's control as a fact favouring cancellation. The proposition only needs to be stated to be rejected. Second, the argument appears to depend on a narrow reading of the heading in the record of decision. But the parenthetical reference to the presence of extenuating circumstances need not narrow client circumstances in which the ground for cancellation arose. Third, principles derived from cases regarding criminal sentencing do not really readily translate into administrative decision-making. The weight to be placed on each factor is a matter for the decision-maker. The applicant falls short of demonstrating a locality. So now they're going to conclude here. The only thing I'll say is that, to be honest, with the state that the virus is spreading in Australia, would you really want to come here and risk it if you weren't vaccinated? That's all I would say. And that's one of the arguments that the government's put forward as well, that they have a duty to protect the people that come into the country as well as the people in the country. But anyway, the application should be dismissed with cost. If the court is minded to grant relief, then the respondent submits that the only orders should be to quash the decision and the costs. It is inappropriate to make any further orders whether there be immediate release or even a remittal to the delegate for reconsideration according to law. As the court raised with parties at a previous mention, if this court were to take orders in favour of the applicant's favour, then it would be for the respondent to administer the act in accordance with law. That may involve the delegate deciding whether to make another cancellation decision, but there are also other powers in the Act, as the court would be aware, or indeed no power be exercised. It is sufficient for the court to quash the decision. From time to time, those orders are made. The respondent will act on the basis of that the applicant's visa has not been cancelled. What the government is saying here is that even if Djokovic wins, they may be able to still cancel his visa under another part of the Act. If the court makes an additional orders for immediate release of the applicant, notwithstanding the above, the respondent submits that the court should make it expressly clear that the order does not purport, or could it prevent, the respondent or any other officer of the Commonwealth from exercising any power to detain that might be available to him or her, despite the quashing of the delegate's cancellation decision. An order for immediate release does not prevent re-detention if there is power to detain. Take a note of that. An order for immediate release does not prevent re-detention if there is power to detain. The express reservation is not then strictly necessary, but it would assist to say so to avoid any doubt about the proposition in the previous sentence. So that is the government's argument. And at the very end, the government has said that even if he gets released, if they've got the powers to re-detain him, they will re-detain him. So there you go. So that is the government's argument. As I said, I've had a brief chat to Poppy Seeds about it, and she said that both sides have really argued well. But we will see at 10 o'clock today as to what, well, it's going to probably take all day. And we'll see what happens. You know, like Fox, they're reporting. I mean, all the. I'll show you this. So these are the news headlines I've just pulled up. So it says, you know, court case may not end. Could be thrown back into detention even if he wins. 5 things. 5 things Djokovic and the government must come clean on. Nadal has hit out at. Okay, federal government could cancel Novak's visa. That's the Herald Sun. Yeah, so they're saying that he could be detained again. So, you know, it's all. So, you know, it's all very interesting what's going to happen. As I said, the other tennis player that was on the same exemption, she left. She got deported. So one's been deported. That's this, you know. So, yeah, so it's very, very interesting. I think the thing that's got is about the fact that he was out and about around the time that he COVID. That's my only thing. So Tennis Australia is doubling down, though. Of course they will. Tennis Australia, this is The Age, has reported this. So this is from The Age when it comes up. Tiley says Tennis Australia in a conflict of advice between state and Commonwealth. Tennis Australia boss Craig Tiley says the Commonwealth rejected a request to assess medical exemptions granted to tennis players weeks before they arrived in Australia. The Australian Open director, speaking for the first time since Novak Djokovic was detained, told The Age and Sydney Morning Herald he believed the decision to allow quarantine-free travel was a matter for Victoria, and that Tennis Australia was caught between a constant conflict of state and federal advice. No, Tiley, border security and border stuff is to do with the feds. Stop covering your butt. Tennis Australia and the Victorian government granted a handful of exemptions for unvaccinated players to enter the Open. Bingo, to enter the Open, not to come into Australia. The process was based on guidelines from the Commonwealth's peak vaccine advisory body, Mr. Tiley said. But tennis officials asked the federal government on 2 occasions in November to examine each exemption to ensure they would be accepted by federal officials at the border. They declined, he said. We asked if they could please assess our decisions. We said we're going to need some help to make sure we're doing the right thing. We're in a different situation today. The tennis chief has been under pressure to explain why he advised players they could seek an exemption based on a recent COVID infection after Federal Health Minister Greg Hunt wrote to him in late November saying that this was not a valid exemption. Despite Mr. Hunt's advice, Mr. Tiley said he believed the Victorian government would approve whether a player would be required to quarantine. This view was informed by a letter from Federal Health Department officially in early November stating exemptions from vaccination will be the discretion of the state, as well as correspondence from Victorian Chief Health Officer Brett Sutton saying prior infections was a grounds for quarantine-free travel. Well, it's up to the state to decide whether you can quarantine, but the state doesn't let you into the country. We believe that the Targi guidelines are what the exemptions were based on, and it wasn't a federal government approving these exemptions, it was state. Is this guy an idiot? Sorry. He said he had become even more confident about the validity of the prior infection exemption when 2 other Australian Open participants entered the country using the same exemption Djokovic arrived. These 2 people have now left country after the federal government reversed its decision to grant them entry. So this is the timeline. So in my opinion, this falls wholly and solely on Craig Tiley, and he should go. That's my opinion. Exactly the false. The tennis boss who has a working relationship with Djokovic said he had no idea there was prospect of the world's #1 being blocked at the airport. All he wanted was Djokovic. This who has a working relationship with Djokovic, he was going to do whatever he could to get Djokovic here. It was a shock, said Mr. Tiley, who communicated throughout the early hours of Thursday morning with Djokovic's agent in Monaco after the player's arrival late Wednesday. Mr. Tiley, give him all the boot. I know. Oh, look, a 5-year-old could have handled this better. Mr. Tiley said he'd not considered resigning. He said he had not considered resigning in the past few days. Well, you should. In late November, health authorities told Tennis Australia on 2 occasions in writing that people who were not vaccinated and had contracted COVID-19 in the past 6 months would not be granted quarantine-free travel to Australia. Mr. Tiley said these letters represented a point in time and should not be taken as gospel. Everything changed before and after, he said. I can go back and look at a letter from 5 years ago. It doesn't apply to what's happening now. What? Is this guy an idiot? I agree, Graham. The feds did mess up. I do agree there is a mess up. How can he say you can't look at a letter from 5 years ago? We didn't have COVID in Australia 5 years ago. He's talking about one that was issued in late November and a correspondence. He's talking about correspondence early November and late November. You always take the most recent one as the one that you respond to. Is this guy an idiot or what? He said he hoped Djokovic will be able to play. Well, Tennis Australia is putting all their eggs, they're hoping. I'd like to see him play in the Australian Open, he told 9 News on Sunday evening. But Mr. Tully, you don't realise that the people of Victoria are not very happy about this and will boo Djokovic, and it won't look very good. In fact, there are people that are trying to get their tickets refunded because they don't want to be a part of it. Mr. Tully's view has highlighted the confusion between state-based rule avoiding hotel quarantine and the federal process for granting visas for unvaccinated people. There's no confusion. The feds let you into the country. The state decides whether you need to quarantine or not quarantine. It's pretty simple. This episode has demonstrated that a state approving a person to skip quarantine does not automatically a person a guarantee to enter Australia. Duh! It doesn't. I mean, this is obvious. Is this obvious? You've got to get into the country before you can get your quarantine free thing. This article has really riled me up because I had this is really riling me up because really this episode has demonstrated that the state approving a person's skip quarantine does not automatically guarantee a person a visa into Australia. I would have thought that was obvious. All this has shown is that we've got complete and utter idiots running things. In my opinion. So look, I believe, in my opinion, that Tennis Australia and Craig Tiley have got a lot to answer for in this. And of course, the feds let 2 other people through, and have since revoked their visa. They should not have ever let them through. So they've messed up there. And probably, yeah, and the state's sort of caught in the middle. But there's lots of allegations. But all of this will be sorted out today in court, I guess. But as I said, those pictures of we'll see, Bo, I don't believe there should be such thing as quarantine free. I believe everybody should have to quarantine. That's just my opinion. There should be no exemptions for quarantine, in my opinion. Well, that's the thing. Who created the fiasco in the first place? Well, Djokovic stated that Tennis Australia assisted with his visa in his submissions. So, to me, everything points back to Tennis Australia. You got to go, yeah, see you, totally clueless. I won't be much longer either because I want to I need to get going too. But I just wanted to put out the government's. I wanted to put out the government's response prior to the hearing started, so that anybody that I wanted to get both sides, and now we've now got Djokovic's submissions and we've got the Department of Home Affairs submissions, and I wanted to get them out before the hearing. And so you're free to watch them, read them, whatever, and make your own decision. I don't know how this is going to end, but as Poppy Seed said, as the department has said, that even if Djokovic wins, they may still be able to detain him. So they could re-detain him. And we could be right back to and then he might decide to challenge again. And then we're right back where we started. So, and one of the things the judge didn't want was this to go on and on and on, and that there'd be constant appeals. Because don't forget, it's likely that Djokovic will appeal if he loses. So, that's going to be another day. So, yeah. It'll be very interesting. Well, the government has actually argued, but the government's point is that he'd met the conditions based on the information he'd filled out. He had met conditions to enter Australia. And that when you go through immigration, that the decision to be issued with the visa then occurs based on the evidence presented. So that is the argument that they're doing that. That's the argument they're stating, rightly or wrongly. Which is true, because if you always read the fine print on the Traveller's Declaration, it always says that you're not guaranteed an entry. So, yeah. Yeah, well, I mean that actually happens in most places. I think I would say it would even happen in Serbia. That but when you actually answer the questions, they can hold you and yeah. Well, also, Graham, don't forget it's a federal election year this year too. Oh, it's federal and state. I think we've got federal and state this year, haven't we? Definitely federal election this year. So I don't think Djokovic's parents are helping the situation either, because he's not being held. So, yeah. Anyway, I just want to thank you all for joining me. As I said, the hearing starts at 10 o'clock, and those of you that are in my Discord, the link has actually been posted there. And if you're not in my Discord, you can join. I think that's the code. No, it didn't work. Yeah, as I said, oh no, there you go. Yeah. Yeah, I think the election is, and they're trying to take a hard line. So anyway, but thank you for joining me. I'll be back on later after the outcome, once we've got an outcome, to give you a quick summary. And then hopefully I can get on later with Poppy Seeds. As I said, she's a migration lawyer, and she can break it down and try and explain it all to us, how we got to this situation, how this happens, how we got here, explain the arguments better than what I can, and what's going to, hopefully she can explain to us the visa that he applied for and what was the issue with that. So hopefully, Poppy Seeds, if you're watching, we've got lots of questions for you. Yeah, so as I said, thank you for joining me. Make sure you hit like and subscribe. If you hit subscribe, you'll get notifications when I'm live and when I upload videos. I've been doing just random lives at the moment, just because of this situation. I got home at 1 a.m. I nearly just jumped on live then, but because I'd received documents, but I had some sleep. So yes, I need to have some more coffee, and I will catch you all again later. Thank you for joining me.